We already reviewed the call 5 weeks after the close of a lease transaction that the water heater was leaking. Let's review some typical scenarios that occur after the listing agent completes the listing and leasing process. 2.5 months into the 1-year lease, the tenant wants to break the lease since they were promoted and are being transferred to California. 4 months later, the tenant is late on the rent to the landlord, so on the 8th of the month, the landlord calls and wants the agent to visit the tenants and ask them to pay the rent. During July, the tenant calls and says the AC is not working, and they have left messages for the landlord for 2 consecutive days with no response. The tenant is finding scorpions in the unit, and despite numerous efforts by the landlord to remedy the problem, the tenant calls and wants to break the lease and wants to know their rights. Obviously, various different situations could occur that would require communication between the landlord and tenant and drag the original listing agent into the matter. Knowing this is going on, the agent should consider managing the property and doing it properly. The listing agent, having made the decision not to manage the property, should clearly spell out to both the landlord and tenant that she is not the property manager, and any and all calls to or from either party needs to be directed to the other. The AAR rental agreement has a section to identify the property manager, so that should state that the owner is managing the property. It is suggested that beyond that, the agent email both parties and remind them that all communication must be to the other and not the agent. The only time that an agent who is not signed on as a property manager can work with the landlord and/or tenant is at the end of the lease, and only for the purpose of getting the property ready for the next tenant. Let's assume that there are less than 30 days left on the lease and the tenant is leaving. The landlord in Texas wants to know the condition of the dwelling so that they can arrange for cleaning and repairs. So the agent goes to the property while the tenant is present. The agent has no choice but to interact with the tenant, so the question is, can the agent avoid being considered a property manager? The answer is yes, as long as she does not get involved in any issue between landlord and tenant. Making an assessment for the owner is not, in and of itself, property management. However, if the agent gets involved in a dialogue about the condition of the property with the tenant and what the landlord might charge for repairs, then that is stepping over the line. This is why it might be better for the agent to visit the property when the tenant is not home, or after the tenant vacates the property. As long as the agent focuses her efforts on making the property ready for showing and for the next tenant, she is not functioning as a property manager. It is a delicate balance during this period. Property management agreements. Just like every other agreement in real estate, property management agreements must be in writing. Every broker that decides to allow his or her licensees to conduct property management activities needs to make a few decisions when it comes to the property management agreement and some of the other areas of property management. First, the broker must decide if the company will use an industry-wide PM agreement like the one offered by the Arizona Association of Realtors, AAR, to all realtor members. AAR developed that agreement and it is available through Transaction Desk. If a broker does not want to use the AAR form, then a broker would need to either create her own or use one that an attorney developed. Regardless of the source, the Arizona Revised Statutes has specific laws that must be followed when developing or using a property management agreement. The statutes have rules of what must be included in any agreement, along with some optional clauses that may be included but are not required by statute. Article 3.1 of Title 32 of the Arizona Revised Statutes contains the rules in ARS 32-2171 through 2176. ARS 32-2173 describes what must be in a property management agreement, as well as the optional features of such an agreement. The statute is below. 32-2173. Property management agreements. Contents. Termination. A property management firm shall write property management agreements in clear, unambiguous language, and property management agreements shall state all material terms and conditions of the property management firm's services, obligations, duties, and responsibilities to the property owner. Be signed by the property owner or his agent and the property management firm's designated broker or the broker's authorized real estate licensee. Specify a beginning and an ending date. Contain cancellation provisions that are agreeable to both parties. Provide for the manner of disposition of all monies collected by the property management firm, including any tenant deposits. Specify the type and frequency of status reports to the owner. State the amount and purpose of monies the property management firm holds as an operating reserve for emergency and other purposes. Provide for the disposition and allocation of interest earned on trust account monies. State the terms and conditions of compensation the property owner pays for services pursuant to the property management agreement. Not be assigned to another licensee or licensed entity without the express written consent of the property owner may. Contain an automatic renewal provision if the property management firm sends the owner a reminder notice at least 30 days before the renewal date. The notice does not negate any other cancellation term otherwise agreed to. Provide for reasonable liquidated damages or cancellation fees for early termination of the agreement. C. Allow the property management firm's broker to authorize a licensed or unlicensed person in the direct employment of the broker, pursuant to Section 32(2174), subsection C, to transfer monies from or to be a signatory on a property management trust account to which the property management firm deposits the owner's monies. Require more than one signature on checks written from a property management account. Contain any other provisions that are agreed to between the property management firm and the owner and that are not in conflict with the requirements of this chapter. Immediately on termination of a property management agreement, the property management firm shall provide the owner with all originals or other copies of all rental agreements or related documents in the property management firm's possession for current and previous tenants. These documents shall include any applications, property inventories, leases, pet permits, default notices, lease amendments or addenda in the property management firm's possession. The broker is not required to keep copies of residential rental lease agreements or related rental lease documents after the termination of the property management agreement. All building plans, environmental studies, conditions, covenants and restrictions, inspection reports, contracts, keys, warranties, personal property, or other documents in the possession of the property management firm. On termination of the property management agreement, the property management firm shall provide the owner with a final accounting of the property's financial status that includes at a minimum, within 5 days, a list of all tenant security obligations. Within 35 days, reimbursement for all monies remaining in the property accounts maintained by the property management firm, except for monies needed for unpaid obligations incurred during the term of the property management agreement. Within 75 days, a final accounts receivable and payable list. Within 75 days, a final bank accounts reconciliation. If there is an on-site management office and any of the records or documents described in subsection B of this section are located on-site, the property management firm may leave the items there for the benefit of the owner on termination of the property management agreement. The property management firm shall inform the owner in writing immediately as to the location of these records. While not required by statute or rule, it is a good idea to require 2 signatures on a check over a certain amount. A broker and her licensees can trust that the AAR Property Management Agreement contains all of the required features as shown above and has options for many of the other sections or issues. Conversely, when a broker decides to draft his or her own agreement or have their attorney draft one, the document must conform to ARS 32-2173.